ladies and gentlemen, good afternoon and welcome. I'm Bob Clifford, the founder and senior partner of Clifford Law Offices in Chicago, and we're now in our 16th year of proudly presenting to you once again a CLE program where we hope to present and will present a quality program that offers 2 hours of free professional responsibility credit. And currently today we have nearly 4,500 lawyers who are registered, we have 4,500 attendees, about 5,000 lawyers registered for this program from 3 states in what we believe to be the largest program of its kind in the country. In my career, I've been committed to attempting to raise anyway, the best I can, the quality of practice of lawyers through deed and example in how we go about things in the state of Illinois as well as across the nation and the practice that we have there. And in addition to promoting civility in the courtroom, we do our best to promote goodwill among practitioners and members of the bar. And I hope that this timely program achieves those goals and is another step in that direction. And that's especially true when we're all now back in the courtroom more often than we had been in the last couple of years, given the pandemic. Today we have, we're presenting a program on refresher on ethics of trial work in the courtroom. Joining us are 3 outstanding panelists in this area of law. James Grogan, known to many of you as the former Attorney Registration and Disciplinary Commission Deputy Administrator and Chief Counsel for the ARDC, and he's currently an Adjunct Professor in Ethics at Loyola University, University College of Law. Also joining us this afternoon is Chris Heredia, excuse me. He is CNA's Global Director of Lawyers Professional Liability. And like everyone who attends this program, if you sign up with CNA, he's going to give you a friends and family discount on your professional liability insurance. Don't forget about that. Thank you, Chris. You're a kind man. And then also, he is a former litigation counsel at ARDC. And then finally, the Honorable April Troemper of the Illinois Circuit Court. She is in the 7th Judicial Circuit in Macoupin County and is a member of the Judicial Ethics Committee. My sincere and personal thanks to each and every one of you for being here today and the time that I know you've taken to be prepared and to participate in this program. It's a great contribution to the profession and the bar, and we are grateful. So thank you one and all. You can find the bios for each of our panelists. They are included in the materials that have been distributed to all of you registered today. We encourage the thousands of you joining us today on the web to ask questions, and everyone watching while you're muted, we encourage you to submit your questions in writing as you were instructed to do in the way the materials are presented, and we will try to get to as many of those as we can. There are materials accompanying the program that you received electronically with your registration. And also to increase interactivity, we will be asking a series of polling questions. We've done this successfully in the past, and it's a lot of fun. You can submit answers to these questions using your phone. Visit Polly, it's POLLEV.com/Clifford Law, one word, to respond from your computer, or use your cell phone to text Clifford Law to TO 22333. That's 22333 to join the polling question slides, and then you can text the answer to each slide that comes up. So without further ado, I'd like to turn to our first hypothetical question, and let us have it up on the screen, Pam. So we have Judge Gavel is presiding over a high-profile criminal case. John Starr, a famous singer-songwriter, is charged with felony drug possession and aggravated battery. And this stems from a brawl at a downtown club. John Starr claims self-defense and denies possessing drugs. A jury trial commences and the jury is eventually sequestered based on the unusual amount of pretrial publicity and attention these charges have garnered. After a 2-week trial, the jury returns a not guilty verdict on all counts. Reaction to that verdict ranges from outrage to celebration. The media coverage blames the jurors for not doing their job and blames the judge for failing to rein in the pretrial publicity. Pam, there you go. After the verdict is returned, Judge Gavel's law clerk posts, now listen to this one, Judge Gavel's law clerk posts an article on social media that criticizes the jurors for returning a not guilty verdict, along with the acronym SMH, shaking my head. Judge Gavel likes the news article posted by his clerk. He then posts an article criticizing his decision not to immediately sequester the jury, along with his comment, sequestering doesn't fix stupid. The prosecutor shares Judge Gavel's posting and comments, so true. So here's our hypothetical. Is Judge Gavel responsible for his clerk's posts? Has Judge Gavel, there we go, that's 100, look at those, 50-50. These are our polling. Let's, okay, 50-50. Yes, he is. 2/3, 80%. There we go. Up, down 90 for 98. Come on here, we're going for unanimity. Right. What really is this? There's a debate here. Okay. All right. Okay, we're gonna hone in on 70-30. The next question. Has Judge Gavel violated the judicial code? Let's see what the people say about this, and then we'll open it up for a little discussion. All right, has Judge Gavel violated the people code? Gosh, well, we got a lot of people that don't necessarily think so. We're edging at 7 now, and now we're at 80-20. Nope. Gavel's in trouble here. 90. All right, we're going back up. I think we're stuck at 85-15. They're going on. And the final question, has the prosecutor violated any of the rules of professional conduct? All right. Yeah, there we go. I think we're kind of stuck around there. 85% say yes. So Judge, has Judge Gavel, turning to Judge, has Judge Gavel violated, is he responsible for his clerk's posts? What do you think, Your Honor?
All right, well, the answer is yes. When you look at the totality of this hypothetical, without a doubt, he is responsible. And recently, the Judicial Code changed and they've added a rule 2.12 called supervisory duties. And under that rule, it says that the judge shall require court staff, court officials, and others subject to the judge's direction and control to act in a manner that's consistent with the judge's obligations under the code. So we'll get into that in just a moment, but it does set the tone that talks about the supervisory role. When you also look at the new rule 2.3b, bias, prejudice, and harassment, it also has a theme in there about the judge shall not permit court staff, court officials, and others under the judge's control to use words or conduct that suggests bias and prejudice. And now we also have a rule 2.8, and it specifically talks about communications with jurors. And subsection B of that mandates that a judge requires lawyers, court staff, and court officials to be courteous to jurors. And then under subparagraph C, it does state that those, again, under the supervision of the judge, cannot commend or criticize the jurors for their verdict other than in a written opinion or in an order. And this does mean that judges and staff cannot post comments on social media networks. So, but let's say that the judge had not had these conversations with the staff. So let me back up. It's very important that a judge does talk to any court staff underneath his or her direction and lets them know of the expectations, lets them know of the rules that the judge has to follow. And then if the judge did all of that and the staff member still posted that, not looking at the judge's context in this scenario, but if you just stop and look at the staff member's context, then that could be an internal employer-employee issue. But when you look at the big picture and knowing what the judge did later, then yes, the judge would be responsible for its staff members' post.
Thank you. Chris, anything both at your work at the ARDC or now in your work in the commercial sector with the CNA, anything like this ever come your way?
Yeah, I mean, I think this is, you know, a timely topic. And Judge, I want to give you kudos for answering yes. I feel like as lawyers, the answer is always maybe, whether or not they violated rules. So I appreciate you coming down on one side or the other with respect to the code. You know, I think here, given what we see in social media on a daily or even hourly basis, I mean, I could very easily see this kind of scenario being something that snowballs very quickly, right? Rather than word of this getting around within hours or days, I could see, you know, the judge's clerk posting something, minutes later, the judge reposting it, minutes later, the prosecutor scrolling through theirs and you know, go ahead and sharing it with additional comments. And so I think, you know, a lot of that, you know, really is relevant when we talk about, you know, how far can we go in sharing that, right? The prosecutor is going to say, listen, I didn't post that. All I did was, you know, add an extra comment. All I did was kind of like it or, you know, put a thumbs up on it. That doesn't really violate any rules. But I think this certainly does at least call into question, you know, the prosecutor's duty in terms of, you know, what they're making with respect to extrajudicial statements, right? So we know that under 3.6, and again, the timing of this, right? We know that prosecutors in criminal settings in Illinois don't really have a lot of recourse once you get a not guilty or you know, the jury acquits, but you know, that may not be the case in other states. And so whether or not this is something that's extrajudicial, we know that 3.6, you know, prohibits lawyers, prosecutors, I should say, you know, in this case from, you know, making extrajudicial statements that would pose an imminent threat to the fairness of the proceedings. Even though they're over, that doesn't necessarily mean there aren't any other post-trial or other remedies available. So I would be certainly hesitant of that. When I was a assistant state's attorney here in Cook County many years ago, I didn't want to post anything, only because I was like, well, I just don't know if that's getting into 3.6 territory, whether I'd say something nice or not. It just wasn't worth it. And you know, so we're starting to see some of that come into play with you know, just social media kind of being ubiquitous with the practice.
It's really changing some things. Wait till you get some of the other hypotheticals. Social media is becoming such, you know, we talked about Zoom becoming a big deal. Social media is very alive and well and growing in the practice of law. Yeah. Let's go on to hypothetical 2, if we may.
Back to that, did you want me to comment about that judge's role too on that? Because I was just talking about the lawyer.
Yes, Your Honor.
No. I'm just in case I have any judges on the audience, and the code did change, so I just want to make sure we take advantage of this opportunity. But
yes, thank you, Judge, because of that judicial code change.
Yeah. So, and I know the first one was about the judge to the staff, but then the judge, you know, is the judge responsible as well? And in addition to those rules that I did mention, there's also the big theme about integrity and impartiality and acting in a manner that promotes public confidence. So we have additional rules. 1.2 talks about judges at all times, not only in their professional, but also their personal life. They must act with integrity and impartiality. And then according to one of the comments, and I'm not sure if it's up on the PowerPoint, but it says that a judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept that restriction imposed. So I always tell my colleagues, listen, you signed up for this job. You may not like it, all these restrictions, but it's part of us, and we have to take this job very seriously. And as tempting as it may be to post or like, especially if you're being criticized for a ruling, technically we shouldn't know about that, but if we are being criticized, you have to stand down. You can't do anything because you are going to be subject to these rules of conduct, and you could get reported to the Judicial Inquiry Board. And then again, Rule 2.2 talks about impartiality and fairness. And by making those comments, it's very clear that the judge's comments could be construed as maybe anti-defendant, pro-prosecution. So you just have to be mindful of how the public would perceive your comments, even if you're trying to defend yourself.
Can we, Judge, I have a follow-up question then, and I'd like to go back to the previous rule. one of the comments that I was at a dinner party not long ago, and I heard someone say, who was familiar, there was a lawyer, he was familiar with these rules and the change. And the comment that was made was that we're making judges we're extracting them from the community. We're making them be in an ivory tower or some tower that's away from the public in the guise of making sure that there's integrity and there's impartiality and people know that they're getting fairness. We're also making monks out of these judges, that they're not being given a fair opportunity to interact with the community. Do you ever hear that kind of from your colleagues at all, that they feel that way?
100%. I think that anymore they feel they're walking on eggshells. They're just, they want to interact. They want to be normal. They want to have, a private life. But these rules make it clear that these rules are with us 24/7. We'll get into it later, but it talks about conversations that you intended to remain private between your friends and family. They could get into the wrong hands, and then now you're subject to these rules. And so, yes, I have heard that. I do think we do feel it more and more. But again, it's part of the responsibility in our profession. So,
Bob, the concepts that we're discussing, they've been universal for a long time. But I think what you noted and what the judges bring up is in an era of instant communication and social media, it makes things so much more difficult, that the modes of communication really complicate things. But these concepts, when we were first licensed, these concepts existed.
Yeah.
It wasn't subject transmission the way it is today.
Right.
I
Thank
do
you.
have a question from the audience from Andrew, who's asking, and the panelists know, have any of these speech restrictions been challenged as violations of the First Amendment that you're aware of?
Judge or John?
I'm not aware of First Amendment challenges. I know that in some of our hypotheticals later, they do ask if these are protected
Right.
under the First Amendment,
Right.
which I think is different than whether or not they'd be subject to discipline under our code. So
There you go.
And remember, we're dealing in terms of privileges as opposed to rights.
Yeah, there you go. And that's an important distinction. Absolutely. Okay, hypothetical number 2, because we'll be coming back to this, I think, in a bit. During a criminal jury trial, defendant Dave is charged, but don't blame me, by the way, for all these names the way Pam does them. And I'd be remiss, by the way, everyone, thank you all for listening to, but I'd be remiss if I did not thank my law partner and Pamela Medeker for all the hard work she puts into this stuff. So, I applaud failure and ignore success when I talk about these creative names of hers. Anyway, I digress.
Well, it takes a village, Bob, I'll tell you.
There you go. All right. So during a criminal trial, defendant Dave is charged with felony aggravated unlawful use of a weapon. The jury congregates in the jury room, which is just outside and adjacent to the courtroom. Before opening statements and while the jury is still in the jury room, defendant Dave makes an extremely loud outburst in court. He angrily is yelling at the top of his lungs at the judge, the lawyers, the courtroom staff, and he does this present in the courtroom, voicing his observations about the injustice in the courtroom and in the criminal justice system in general. The judge, Judge Jordan, in her chambers with lawyers present, questions the sheriffs who have been assigned to maintain the custody and safety of the jurors and the decorum in the courtroom as to whether any jurors overheard Dave defendant's actions in court. Before the deputies could answer, however, the judge jumps in and says she'd rather not know and makes a silent motion to the deputies in which Judge Jordan puts her hand over her mouth. Judge Jordan then proceeds to inform all counsel of record and her courtroom staff that she would acknowledge the outburst for the jury, but tell the juries it was an unrelated party who was yelling. Judge Jordan does not ask for input of the counsel of record at all and motions for all parties to head back to the courtroom to bring in the jury and commence the opening statements. So okay. So is defense counsel required to confer with the client about how to proceed? That's our first and 100% say no. Okay, I'm with you. I'll give you. Oh, here we go. The other side's being heard from. There we go. Okay. All right. We're narrowing it down here, Joe. All right. So you're getting in that the 70-30 number again. Oh, no, no, it's changing. So I say certainly the majority, a good majority, think the answer to that one is yes. That defense counsel is required to confer with his client about how to proceed. I think, you know, look, I think it's standard practice in certainly in the civil side of things that, you know, you speak to your client about the environment and about how to react and not react. I think that's just part of good lawyering. I take my clients over to the courtroom and during you know, find an empty courtroom and talk about what it's like and how to be comfortable and you know, don't overreact and don't jump out of your chair when you hear something that you don't like, or don't start clapping when you do hear something you like. I mean, that's part of the deal. Okay. Do any counsel of record owe any duties to the jury as a whole about the judge's announced course of action? I don't know, Judge, what do you think about that one?
Let's see, Judge.
Wait till let's see what the people say.
Yeah.
Do any counsel of record owe any duties to the jury as a whole about the judge's announced?
Okay, so
Yeah, go ahead, Judge.
yeah, so here I think that you wouldn't do that, but I do think that counsel would have a duty to ask the judge to reconsider, because if the jury was informed that it was no one related to the case, let's say hypothetically that the defendant then decides to testify and the jury can tell the same voice who had previously caused that disturbance, and that could be really prejudicial to the defendant. So I don't know that they need to go and bring it up to the jury, but I do think counsel needs to ask that judge to reconsider. Yeah,
you know, Judge, this is kind of related, but I've had a conversation with lawyers over the last week where the concept of reconsideration has really been front and center, and where it came up was when the judge decided in an open hearing that they're going to do X, and then lawyers just accepted it, even though their instincts were, well, Judge, maybe there's a feature that you hadn't thought of here that you know, lawyers ought to have in their toolbox, the notion that asking the judge to rehear something is something you always want to consider and put out there. So, okay, well, here we got a 50-50, so no one wants to decide yes or no here. Everybody's it's a mixed bag. All right, next one. Do any witnesses who may have also overheard the courtroom incident have a duty to report to the court what they heard? Now we're talking about witnesses having a duty. Judge, I'm going to go back to you on this one then, if I may, first.
Yeah, I couldn't think of any rule that requires a witness to report what they heard, or them to report to a witness. Again, that's crossing into a different territory that no rule applies. I'm not sure if there's case law out there, but there's no ethical rule that applies to this.
Yeah, I think a good rule of practice, though, is we always in our trials have we have someone in our trials who's in the courtroom all the time. So if I'm on trial and the judge says, okay, let's take a recess, everybody go into chambers, or let's take a recess to go into chambers and bring the court reporter, we still have someone, an observer in the courtroom, seeing what's happening. You always want to know what's going on in that courtroom. Chris, did anything like this ever come up in any of your, when you were at the ARDC or in the cases that you see in your work?
No, I mean, but I think you make a good point, Bob, is that you need to make sure it's important to have somebody from your firm, right, to be able to see what's going on in the courtroom nonetheless. Whether or not that calls into a duty that they have to then report, their counsel of record, they probably don't. But again, you know, you've got this kind of, you know, in Illinois, we've got this 8.3B essentially, right? It's our Himmel obligation, but for judges when they violate, you know, one of the canons or codes that call into fitness, you know, with respect to their holding of the office, sitting on the bench. So, you know, there may be a duty depending on one, if that witness is a lawyer, two, if it's a lawyer from your firm, and three, you know, whether or not they think that rises to that 8.3B level to report them to the Judicial Inquiry Board. You know, I think that's at least, and the other component too, and why this is so difficult is because if you've got this duty to report a judge to the JIB, right, and Now you've got prosecutors who are in front of that judge every day, kind of worried about how their daily call is going to go, knowing that they've got to report a judge. Certainly it doesn't get rid of their obligation to do it, but it makes that decision that much harder when they're thinking, did I actually hear what I heard? Did it seem like the judge was indicating that, the sheriff shouldn't say anything and everyone should stay quiet? And what about the fact that nobody had actually quite told the jury something that was, or the impaneled jury, something that was quite, dishonest or fraudulent yet? They haven't gotten to that level, so they think maybe I'll just sit on it. But I think that at least calls into mind some of the obligations of what prosecutors and other lawyers in the room should be considering as they go through this.
Okay, well, thank you. All right, let's go to the final question on this one, Pam, is that would counsel of record be required to report Judge Jordan to the Judicial Inquiry Board for conduct they witnessed, for how the judge handled this proceeding? And assembled say, wow. Well, let's give it a chance here to balance out here.
Might be close.
I'm surprised.
Yeah.
Well, I'm going to start the conversation. What the heck did the judge do wrong here?
Here's my guess, Bob. Here's my guess. There's the line in the hypothetical that says the judge is going to tell the jurors that it was some guy down the street that was yelling, and it wasn't the defendant, which the judge should not have gone there.
Well, but wait a minute. Let me be the devil's advocate.
Okay.
The judge, I thought that was how the judge would handle it. Okay, wait a minute. If I say it's the defendant going wacky here, that's going to prejudice the jury. That's really going to get the defendant sideways with some of the jurors. Isn't it a neutral if I just say, folks, I got other things going on in my courtroom. You might have just heard a disturbance in here. It's got nothing to do with this case. Is there something wrong with that?
Yes.
Oh, okay.
Well, from the judge's perspective, now I'm perpetuating a lie. Like, that is not truthful. And that's part of our ethical duty for integrity, and that is honesty and truthfulness. So I think by adding anything, that is now creating a lie, and that's not something we want to create as far as judges go. So I do think that there is an issue, because in your hypothetical, the judge actually did state a lie. Right. And again, if that's just perpetuating the situation, and it could really taint that defendant's right to a fair trial. There should be further discussions about it.
But wait a minute, the judge was trying to do it in a way that wouldn't taint the defendant's right to a fair trial by making this something that had nothing to do with the defendant.
Well, I'd say that if the defendant goes on the record and says, listen, I don't object, I'm fine with this approach, I don't care, I'm not going to raise anything, then I think you're okay. But the situation is now the judge has lied, the defendant decides to testify, there's voice recognition, now the jury's going to hold it against that person and think they're wild, crazy, whatever. And so you don't want that to be an issue later. So I don't know.
The assembled group agrees with you, and maybe to your point, if the defendant hears, well, the judge just lied to the jury, I might as well do it too.
Yeah. So again, it's a high level of standards. So.
Judge, I have a quick follow-up point. I think too that would call into question. Let's say even if the defendant's client, approves of it and says it's fine, does that still call into question the obligation of defense counsel to say, well, now I know the judge is lying, even if my client wants it, I still have this duty, right? I still have to worry about false statements being put to the tribunal. Right.
And the judge didn't have to go there with that statement. And that's why earlier when the panelists suggesting to the judge that maybe that the matter should be reconsidered, perhaps trying to artfully say to the judge, maybe, it's better if the judge didn't say anything about an individual.
Right.
I'm just making a decision, go ahead.
Yeah.
We have questions coming in, and for instance, Joe is asking, by making a false statement to the jury, isn't the judge, quote, perpetuating a fraud on the court?
Right. That's exactly what I was thinking. So yes.
That's what Judge Troemper saying. Right.
Yep.
And
that's exactly the concern.
He's asking if are some of the judicial rules of conduct overbroad or vague, and I don't know if that's can be addressed exactly here, but, and I know these rules are new, Judge, but,
Right. So I think that if, back to the reporting requirement, the new rule under 2.15, it talks about duties to report. So if it rises to this level, then yeah, there would be a duty to report. I mean, from a judge's perspective, I know lawyers may have a duty as well. But it undermines, I think, just the overall respect for the legal system when the judge is going out and telling a lie. That's the issue in this scenario. And at the end of the day, again, back to Rule 2.8 about keeping decorum and demeanor in the courtroom, it's the judge's responsibility to make sure there's order in that courtroom. If that defendant had the outburst, that judge should go in and address that and not ignore it. Because again, I think that minimizes the important role that we play and the level of respect we are trying to achieve. And one of the comments says ignoring, I mean, yeah, just by ignoring it, it's not helping the problem.
You know, Bob, when you mentioned reporting, I mean, this is especially with the lawyer involved here, because the Himmel rule in Illinois, which is reporting certain misconduct, either of a lawyer or in another element dealing with judges, Himmel's having its 35th birthday. And when you think about how long it's existed and what the focus should be, I will tell you that when we're dealing with a judge, subsection B basically suggests that the trigger, the way that you must report the judge, is if the judge has done something that appears to be a substantial violation of the Code of Judicial Conduct. So, and this begs the question, well, is a lawyer presumed to know the Code of Judicial Conduct, especially since judges said we have a whole new code? And the bottom line is yes, we have to know it, because there's a little hidden rule. It's not in the materials here, but it's a hidden rule that basically says that a lawyer shall not knowingly assist a judge or a judicial officer in conduct that the lawyer knows is a violation of the Code of Judicial Conduct. And what that comes down to is we're presumed as lawyers not only to know our lawyer's code, but you've also got to know the judicial code.
Right.
So
Wow.
it's really tricky, but you've got to be prepared to understand that. But not everything has to be reported. The system would crash and burn if a lawyer was duty bound to report everything. And you hope it's not that.
I do have one last question that's coming in from a few people, including David Sasson, former Illinois State Bar Association president. Why can't the judge just ask the jury to disregard what they heard instead of telling an untruth?
Yeah.
Judge?
Right. I mean, that's always an option, of course, just being honest about it. And I mean, the defendant is the one that chose to have the outburst, right? But yeah.
Yeah.
That's a reasonable.
But wait, but it's the judge's job to make sure that the case is decided on the merits, not on the poor character training of being the devil's advocate again here, right? I mean, but I think I like that instruction about the outburst. Just you got to ignore these kind of things and decide the case on the evidence, right? Yeah.
Great.
Okay. All right. Hypothetical 3. Here we go. I see Fred Flintstone. Okay. All right. What was Fred's wife's name? It's
Wilma.
Wilma. All right. So Fred Flintstone is an Illinois lawyer. He is representing a longtime client in a proceeding where the client is seeking damages for a breach of contract. The litigation had been acrimonious, and Fred and opposing counsel have been attacking each other during the full course of action. During an in-person judicial proceeding, Fred turns to his opponent and says, "You, madam, are a worthless piece of intestinal material." Ooh, okay. Even though this comment may not reflect courtroom civility, can Fred make the comment under the First Amendment? Holy moly. Let's see what people say about that.
Well, and we did have a question earlier while we're looking at this about elaborating, as Jim had mentioned, about on privilege versus the right distinction. So perhaps Jim will be talking about that.
The privilege versus the what, Pam?
The First Amendment being, you know, when you speak in a courtroom, it being a privilege versus First Amendment being a right. And I think Jim is going to elaborate on that.
Well, there are rights and there are privileges, and privileges are more vulnerable to attack, I suppose, is with Jim's point. Am I right, Jim?
Yep.
Yeah.
Looks like.
All right. Well, talking about Fred Flintstone here, 62% of the people think that what he did was okay. Wow. All right. Well, how about you, Mr. Grogan? What do you think about what Fred had to say?
Oh, Fred, it's not good. It's not good at all. And you don't do this. I think of myself, what was my job? My job was to represent clients and not make the judge's life difficult. That was my focus when I tried cases. And in this situation, Fred's remarks are limited. A lot of times, and I have a hard time, expressing this to students in law school, because they think the First Amendment is unlimited, but we are limited as lawyers to what we do, what we say, what we can review. So the bottom line here is you have to distinguish vigorous advocacy with obnoxious comments, and a judge can certainly limit obnoxious comments. And we're seeing, and maybe Chris could tell me what he's seeing in the malpractice context, but we're certainly seeing in a lawyer regulatory context more and more of these sort of cases where we're going to get some more hypotheticals about this in a while. But it's important to emphasize that the lawyer's code says that you cannot engage in conduct that tends to defeat the administration of justice. So you cannot intentionally disrupt proceedings through the use of obnoxious behavior, no matter if the words might in a street corner be protected under the First Amendment.
Chris, what are you seeing in your world now?
Yeah, I mean, I think in one of the cases that we can talk about later, with respect to the regulatory side, you're certainly seeing this age-old debate of the First Amendment, and where they fall in line with the rules and how far lawyers can go. But once you start seeing actionable consequences, like, in one of the more recent ARDC cases, I think it was in Reed-Peak, you see that really start to affect, and the hearing board comment that it affects, the entire settlement process as it is. So you're starting to see, opposing counsel that may be reluctant now to work on settlements or to communicate or to be able to talk to opposing counsel who's like this because you can't get anywhere with it. You feel, it's going to affect the bottom line and ultimately affect both clients' rights. So we certainly see that, popping up, unfortunately, in this debate of, not only in civility, but how far can lawyers go in advocating for their client, especially when we see, states debating the 8.4G, the model rule 8.4G, that anti-discrimination rule. That's going to come up more and more often. And then how it affects the bottom line for the client is really the ultimate goal that I don't see going anywhere anytime soon.
Well, I do know that if I got back to my office and it was reported to me that a Clifford Law lawyer was the subject of that comment, that lawyer would be in a lot of trouble around here. So, at some juncture, you just have to, those kind of comments demonstrate a weak mind. And to me, and lawyers need to be above that.
Can I mention something too? And I'd be interested in the judge's comments. In Cook County, there's maybe 1.5 million lawyers or something like that. It feels like that, right? But if you're in Macoupin, if you're in a smaller county and you try to say stuff like that, what happens to your reputation? Or how does the bench view you if this is a standard practice of yours?
Well, there are some personalities that don't blend very well, and you kind of know that in advance. And you just set the tone early on, again, because it's smaller communities, and this isn't just in my community, but anywhere that's smaller. You just set that tone, and you just let them know that if they can't be civil, then you're terminating the hearings. And you use the word contempt, and I've unfortunately had to find a couple lawyers in contempt in the years past for some very egregious conduct, but sometimes you just have to use that word to remind them this has to be a professional setting. Even if you have disagreements, your personalities are opposite. I always say, take it outside these four walls of the courthouse so I don't have to see it or I don't hear it, because if I see it and hear it, I will respond accordingly. And you just set the tone early, and that's how you handle it.
There you go.
Is this based on a real case? Somebody's asking.
What's the question, Pam?
Is this based upon a real case?
Was this based upon a real case? I believe the answer is yes.
Hypothetical? Okay.
The hypothetical, yeah.
Yes. Okay,
Jim, isn't it, I think?
yep. All right, well, we must have persuaded one person because the number went down from 61 to 60%. All right, let's go to the next question, Pam. Okay, and
Okay,
it's related.
hypothetical 4.
Can Fred make this comment to an acrimonious opposing counsel's face in court without the court reporter present? Well, I suppose the answer is Fred can say it wherever the heck he wants to say it if he's going to say that. He doesn't need a court reporter. And if he had any type of brain, he wouldn't say it in front of the court reporter.
Probably prefer it's not, so.
Yeah, exactly.
And again, anymore, our smaller communities, we have the electronic recording system, so you're on at all times, so.
There you go. Do you hear? All right, I have a question about that, Judge. Do you hear do you hear what's going on in the courtroom in chambers?
I know, because I don't turn my microphone on in chambers because I don't want to say something. So no, I don't have that on. No.
No, another lesson from the trench. I mean, nowadays when you're in the courtroom, you got to be assuming that you're on and that someone's listening.
Right.
Yeah, there's a famous lawyer disciplinary case where a lawyer was sanctioned because those electronic recording systems picked up that he was suborning perjury with his client. And when they were preparing the record for appeal, they realized the conversation and, had to do something about it.
Right. Oh,
We do have a question though, and some of you are from the ARDC with respect to obnoxious attorney behavior from Ms. Anna's asking towards opposing counsel. When does the ARDC really do something? I ask because this person has encountered a lot of this sort of bad behavior, but have been told the ARDC will do nothing to stop personal insults and attacks against counsel unless it amounts to a physical attack. True?
I think, at least from personal experience in cases that I've prosecuted that involve this type of conduct, I think you're seeing the Supreme Court take a different tone on this than, the ARDC and Supreme Court would have in the past. I think they're in recognition of this long systemic, acts that we know exist in the profession. You're certainly seeing the court take more disciplinary action involving, more increased sanctions more often. And so you're seeing that tone starting to change. I'm sorry to hear that person may have had that experience. When I was at the ARDC, I think we took it, pretty seriously, regardless of whether or not there was physical contact. Comments like that were taken very seriously.
Right.
Jim, I don't know what you take.
Right. Again, especially with discriminatory comments, it's something that was always considered to be serious. You don't need a physical touch or a physical assault to kick in the rules. It's just, is it disruptive? Is it hateful? Does it violate the rules? And there's going to be a look into the matter. Now, it may be such that the ARDC would view this as an isolated incident. Perhaps the lawyer apologized. But one thing that you try to keep in mind is this is a pattern of behavior of the person. Is this something that is reflective of something that's deeper seated? Is this lawyer have big problems and is essentially out of control? You always have to be on the alert for that.
There you go. All right. Well, 63% didn't think that he should be doing this without a court reporter. Okay. I'm not sure what to make of that answer, to be honest. Let's go to the next one. What if Fred's paralegal, who always accompanies Fred to court, actually made the comment to opposing counsel? Can the attorney be held responsible for his paralegal's words or conduct? I know what the answer is here. All right. I think this one's pretty self-evident. Let's see. There we go. All right. So the rules of respondeat superior prevail. Does anybody have anything to add to this discussion on this one?
No, just how it would be different. I mean, the judicial code says that, yes, the judges could be responsible. So
yeah. I will say this again as a practice tip. I mean, when we're developing like a trial team, we do spend time with staff to train them about, courtroom decorum and courtroom conduct, and just like with, training your client about, you know, how to act in a courtroom, what to expect. Don't get, you know, shaken up by something that you're unfamiliar with. We try to do the same thing with our, you know, our paralegals and other staff. I mean, they have no reason to really understand how to navigate in that space. It's new to them. So, you know, good tip is to train your paralegals about, you know, all that stuff.
Yeah, and Bob, you know, what you do as a practice is something that is required by the Lawyers Ethics Code, that you as a supervisor have an affirmative responsibility to make sure that everyone's conduct comports to the rules. And that if a lawyer perceives that a subordinate, either a law clerk or a paralegal or an associate in the firm, is doing things that are inappropriate, the mandate is that the lawyer basically calls that to the attention and remedies it in an appropriate way. So what you're doing complies with the rules.
There you go. Okay, Pam, hypothetical 4.
We have loads of
Oh, excuse
questions, but I think, yeah, we need to move on. Right.
Right. Yeah. I mean, well, do you want to talk? I mean, I don't think we need to cover the First Amendment, Second Amendment part of that. Well, let's go back.
Well, just somebody's asking, for instance, if a judge has a quiet demeanor, what's your suggestions for making a record or otherwise intervening to stop this behavior? Somebody else is asking, what if somebody makes a comment and you think your Zoom is off and you make these comments, but your Zoom is on and everybody hears it?
I would say that Zoom is considered a courtroom proceeding, whether it's on or off, and they should conduct themselves accordingly.
Yeah, and I think I skipped over one of the last questions, and that was, you know, what if Fred had told the opposing counsel, you know, there is a Second Amendment around here, and just because weapons aren't in the courtroom doesn't mean that they can't be brought to the parking lot where your car is parked. I mean, you know, that's obviously out of bounds, and we would hope people wouldn't do that. And there are rules against it. I think that's, if something like that ever happened to you, I think that's a reportable offense that you would not only want to maybe bring to the ARDC, but you might also bring it to the court's attention. That could be a threat. You might want to bring that to the state's attorney. All right. Okay.
You know, Bob, it's dangerous out there in this day and age. You got to, you know, you got to take care. So behavior like this has to be brought to someone's attention, in my opinion.
I agree. Okay, Pam, next one.
Yes.
All right, so here we have, and it's a homicide trial. Judge, you're very much aware of those. It's about to begin, and the judge circulates the voir dire responses to questions asked of the panel. As the prosecutor asks questions, her co-prosecutor searches for relevant information on her laptop that may or may not be disclosed. Through juror number 4 responded that he was never charged with a crime involving firearms. The co-prosecutor found a newspaper article reporting that he was charged as a juvenile in the killing of his mother. In open court, the prosecutor states that she was as proof that juror number 4 lied and was served time in juvenile detention for killing his mother, as well as subsequent non-firearm related crimes. And juror number 4 admits it in open court and says, yes, I did kill my mother, but I thought that stuff was a bad period in my life and was over, and there's no relevance here. Well, there's a lot of questions baked into that one. But, you know, can the co-prosecutor find outside information not readily available to the parties to supplement their information during questioning of the voir dire? Let's see what the assembled say, but Judge, I'm going to go right at you first on this one. I've got.
I want to wait and see what they all think first.
Yeah.
You can go ahead, Judge.
It's looking like the majority think that, yes, they can do outside research. So yeah, typically, I don't know how all counties do it, but they'll get a list of potential jurors and they can, or their questionnaires. So they know the names in advance. So it's not uncommon for firms or the parties to do outside research just to get additional information. I believe here, though, it's the manner in which it was handled that would really be inappropriate, because it's under Rule 234, Supreme Court Rule 234, you know, usually the judge will say, give me your list of questions if they're going to allow them to ask questions. So you kind of have an idea, but by asking that question in front of everyone, I just see it could have a really chilling effect on other potential jurors. And the proper remedy there, I think, would have been to just do a for cause if you found out that potential witness was not being truthful during the
Is
board.
that, Judge, is that, I have two comments, question and a comment. Is, when you get a juror that basically lied, right? Is that something that you have a duty to do something about? I mean, that juror committed perjury in front of you.
Right, absolutely. I don't know if you do it in broadcast and blast him in front of everybody. Again, it was it's a private matter that he was involved in as a juvenile. So you got the juvenile component as well.
Right.
That information was confidential. If they found a newspaper article, obviously that wasn't confidential or privileged at the time. But yeah, there is a big issue on perjury. I've not had a blatant juror lie like that. And I'm not sure how I would handle it, but I think that it would have to have some type of consequence for that. So again, that's how you get fair and impartial jurors, is by being honest and truthful. So I don't know, I would have had a problem with how it was just blurted out in front of everybody. I would have probably just asked the judge for a sidebar, talk about it privately, and then let the judge decide how we should move forward on that.
And the other thing I'd like to just bring up, so this is going on all the time now in cases, right? Jury, if in any sophisticated case in particular, with jury consultants involved, there is an immediate effort being made during voir dire to frantically search the the available social media outlets for information about people, and that's a whole topic in and of itself about how do you handle that information, what the rules are. Counsel would be well advised to study that issue, those rules, because there are some do's and don'ts when it comes to that. So Pam, let's see our next question. And this is where, upon discovery of the information that may be relevant in a homicide case regarding jurors number 4, prior use of illegal weapons, did the prosecutor properly handle the matter in open court? I mean, I'm pretty sure we kind of covered that.
This is based on a true case. When I was in a courtroom called for jury duty.
Okay.
The judge mentioned that, right, it was surprising it was done in open court instead of, in chambers or sidebar.
Well, Pam, at times you muffle a little bit, so be careful that we have.
Okay,
I think that, to the judge's point about how how it was handled in open court, maybe that prosecutor was thinking that's what they needed to do to get rid of the juror, as opposed to wisely taking what judge would have suggested, and that is coming to the court with a motion for cause. Or you're just thinking that the court might not have been tracking along that, but clearly the majority believe that the prosecutor improperly handled this matter.
Right.
Okay, well, let's keep it moving along, Pam. We got some ground to cover here. So we got lawyer Lauren is a member and shareholder in a firm of 2 shareholders and 7 other non-shareholder attorneys. Lawyer Lauren, am I supposed to say that 10 times? All right. Lawyer Lauren and her firm represent the plaintiff in a breach of contract action before Judge Justice, which has been pending for multiple years due to discovery delays, the pandemic, and the defendant's retention of new counsel on a regular basis. Trial is next week, and lawyer Lauren has just learned that Judge Justice had a sexual relationship 10 years ago with another lawyer in Lauren's firm, Lawyer Lost, cleverly called. And Lawyer Lost has never been involved in the litigation, which in the sole exception of bringing the client to the firm. So Lawyer Lost is the referring lawyer to the firm. And this was long before the action was filed and Judge Justice was assigned. Judge Justice to generally be resistant to delays in cases, given its long pendency, and having had multiple trial dates already set in this one and reset repeatedly, the judge is eager to move this matter along. Okay. So upon learning this, does Lawyer Lauren have an obligation to, number 1, inform her client of what she's learned about the prior relationship? Well, let's see what the assembled believe. 100% so far say yes. She has that up. Now we're down to 75. Okay, now we're 56. They got the boards. We got all the questions up at one time here. So the questions are, Was she supposed to notify the judge of what she's learned? Or was she supposed to notify opposing counsel? And was she to stay silent, or just stay silent on the issue, given lawyer lost long involvement in the litigation? So let's see. First off, the assembled group agrees that the client needs to be told about this prior relationship. Is there any doubt about that among Chris or Judge, you think? Any doubt about that?
No, I mean, I would try and work backwards here. I think, you run the risk of, depending on how the last relationship ended, it may not be going well. And so I'd certainly want to let the client know. I think you need to, but I'd at least want to be able to disclose, talk about how to proceed, what the judge knows, what the other partner in the firm knows. And then of course, communicate that to the client and figure out if you do need to figure out a different tactic. If, granted, that won't change the obligation of the lawyer if they need to disclose it to the court, but nonetheless, communicate that. I would think the client's input would be essential to determining how that goes forward. And that makes it's even more clear if the case goes south and it was because none of this was disclosed. What do you think, Judge?
I agree. And again, a lot, it's going to depend on the back end of it, right? Like, what are the judge's rulings like? Was it a bad relationship? Later, we learned that the judge didn't even know about that this lawyer worked for this firm. So I think you have to look at the totality and.
And then you got 10 years of time too.
Right.
And then we got, so the vast majority believe that there is no responsibility to inform the justice of what she's learned. And that's probably a good thing, because maybe the judge would take it as okay, what are you trying to is this extortion or something that's going on here? That would be a problem. Are we supposed to notify the opposing lawyer? The majority doesn't think so. What do you think, Chris? Should we inform the opposing lawyer that 10 years ago the judge had something going on with one of my partners?
No, I think, as Judge said too, it's really based on the totality of the circumstances and whether or not this creates a conflict of interest, right? And so part of that is how you're going to communicate to the client. The other part of that is how you're going to communicate, if so, to the judge. And then that, I think, based on that, will help you determine if this is something that needs to go to opposing counsel. I think the assembly's right here. I don't think that this is something that needs to go that far. And based on the totality of it, 10 years ago, there's no other connection to the partner in this litigation here. They weren't involved in any of the work other than, being the initial partner to bring the business in. So I would think that that's right.
All right, and then we have, I agree. And then Pam, we have two more core questions that go with this. And one is, does the fact that Judge Justice does not appear to know that that lawyer lost is a partner shareholder at lawyer Lauren's law firm, relieve lawyer Lauren from or change any of the above allegations? And so once again, the judge does not appear to know that lawyer lost is a member of the firm. Does that change any of the above allegations? And I think the assembled quickly reached that the answer to that is
Right, we touched on that.
yeah. All right, so then finally in this question, core questions, if a conflict of interest exists as between the law firm and its client as a result of the past relationship, are these conflicts waivable? Well, first off, let's talk about whether or not they exist. You think they exist? Why do they exist?
Yeah, I mean, I think, again, when you look at the totality of the facts here, length of time is certainly important. When you look at, there's a whole host of factors when you talk about connections and relationships with judges. And I think the ABA, I think it's opinion 488, talks about how to assess that and how close those connections are, right? I think that's going to factor in terms of whether or not, the partner and the firm, their representation of the client is going to be, materially limited based on this prior contact. It seems like it may not. It seems like it's so distant and it was so, it may have been insignificant and it may have had no other effect on the litigation. I don't know if it quite gets to the conflict, but if it does, that may certainly be something that's, I would think, at least waivable with respect to the client. You talk to the client, let them know, what that connection was, the nature of the relationship. The client is ultimately going to decide. I don't see how, waiving this kind of will always continue to pit the firm's interests, for their client against the firm's own interests or the partner's interest in this prior relationship. It certainly seems to me something that would be waivable. I don't know, Jim or Judge, if you guys think of that.
You know, when I read this, one of the things that flashed through my mind from a practice perspective was that there's so much that is baked into the consequences of these decisions. When, you know, when you start taking this to the judge, you know, how does this change the dynamic of whether or not the litigation can even go forward, and all these, there are just a whole bunch of elephants in the room that pop up when these things come about. So, you know, but I have to tell you more and more, I don't know what folks are doing in their own practice, but we are constantly seeking ethics counsel on a lot of what we do, just to make sure we're doing it right. I mean, I think that's just a good practice.
Well, you know, Bob, the rules also permit you to reach out for that ethics advice.
That's right. That's right.
So it's critical that be. And Chris, you could speak in the civil side with risk management and what you're there for.
Yeah. Well, you know, Jim, what you just said is so true. You know, real life matter. We just had a case here in the office where we were troubled by something going on in the communications with the client that we felt obligated to go to the court about. And we sought ethics counsel, and is it 1.6?
Yep.
That allows us to disclose information to that counsel to give us advice that helps us proceed with the court. And I mean, so these rules really exist to help lawyers navigate and get it right. And that's one of them.
Right. Yes, we have a question. Would this not really amount to improper ex parte communication to go to the judge on this issue outside the presence of opposing counsel?
What was the question?
What's the question, Pam?
Sorry. The question is, would this not really be improper ex parte communication to go to the judge on an issue that's outside the presence of opposing counsel?
Yeah, I don't think you can do that. I don't think you can do that. I think that's where the lawyer takes advantage of 1.6 and gets some advice here about how to proceed.
Because if the lawyer did that, then we have rule 2.9 about no ex partes, then we've got to go disclose it. So whatever they were trying to avoid now has become an issue, and it's out there, and when it didn't even have to be an issue to begin with. So yeah. I think though, if the hypothetical were switched, and let's say it was a really, really bad breakup and the judge did know about that relationship and there were some adverse rulings and they wanted to, then the parties found out about this relationship and then it raised a red flag, maybe then you do a substitution for cause if in an extreme case. But yeah, under this scenario,
asking about that, judge, why wouldn't you just ask for a new judge then?
Right, but it'd have to be for cause, and then it gets reassigned to another judge. But that'd be a way you could handle it as well. But under this fact pattern, it's again too far removed, not a conflict.
There you go. Pam, let's just jump to hypothetical number 6 now.
Yes, please.
Okay, so here we have Judge Gabel runs a civil call. Jennifer Partner and Robert Associate appear for the plaintiff on an employment discrimination case for a routine status. Also present is attorney Mary Defense for the defendant. The case has been assigned to Judge Gabel for over a year, and the parties had previously conducted a pretrial settlement conference with the judge. The judge and the parties share some small talk before discussing scheduling a final pretrial conference. Judge Gabel, however, notices that Jennifer Partner seems confused and unfamiliar with the case despite the multiple appearances and prior settlement conference. The parties prepare an agreed order and ask to approach. While there, the judge smells alcohol on Jennifer Partner's breath. So we got a bunch of baked in questions here. Does Robert Associate, now we're talking about Robert Associate, have a duty to confront Jennifer Partner and ask her if alcohol was part of her breakfast? Is call the confidential hotline of lawyers for the LAPA program that we have here in Illinois, Lawyers Assistance Program. Wasn't that started by Warren Tupel? Or I think so, Lapel. That was under his era as says ISBA president. Should he tell Judge Gavel? I think there we go. People want to know. Or do anything. Robert Associate isn't Jennifer partner's babysitter, and she has plenty of staff around her, surrounding her with who are supposed to know her behavior better. Perhaps this was an exception. What's the assembled say? First off, should he confront the associate confront? All right, 19, 20. Yeah, it's dangerous ground for him to confront her. I think the assembled agree. Should he call the confidential hotline? Yeah, maybe. I think the majority think yes. That's a pretty good answer. How about tell Judge Gavel? Ooh, don't want to go on that one. Most of everyone thinks no. And then do nothing at all. He isn't her babysitter. Well, I think 10% only think he's not her babysitter. So you got to put the D and B together. What do you think, Judge? Well, how would you handle it? Let's not talk about Robert now. Let's talk about the judge.
Yeah. So because I was going to say, I don't know what Robert should do. I guess B was the best option there. But again, under the Judicial Code, we have Rule 2.14, which is about disability and impairment. And it talks about a judge having knowledge. And at the beginning of our Judicial Code, there are definitions of what knowledge means. And knowledge means either actual knowledge or knowledge may be inferred based on the circumstances. So here, the fact pattern illustrates and indicates that the judge does have knowledge of the impairment, smelt it and noticed her demeanor, and she was confused and unfamiliar. So the judge is required to take appropriate action, which may include or which could include a referral to a confidential agency, to the lawyer assistance program where it's actual. And if it's not actual knowledge, but reliable knowledge, then the judge is supposed to take appropriate action. So, and then under Rule 215, I mean, if it's argued that this lawyer has violated the rules of professional conduct, then Rule 215 mandates that we report that to the ARDC, and it does use the word shall in our Judicial Code of Conduct. And so what it states is that by ignoring or denying this type of behavior and conduct tarnishes the legal and judicial system, and it would erode public trust and confidence.
There you go.
Bob,
Jim, anything to add there?
I think it's important here to understand that we're dealing with lawyers and judges with their own separate ethics codes. And what I think is critical with this new Illinois Judicial Code, I really got to congratulate the people that worked long and hard on this. And this is really the Illinois Supreme Court's most recent statement on the issue. And I think it's just focusing on the Judicial Code. They want judges to do something about it. They just don't want people to forget about it. One of the problems we have with the lawyer's code is the reporting requirements typically only deal with moral turpitude sort of offenses, a lawyer who lies or cheats. But here we have someone who's been drinking, appearing at a court session, and we've got this associate here who owes duties to the client, and the partner is a mess. I would suggest to you that the Illinois Supreme Court last year created an elder law commission. And one of the charges of that commission, Bob, is to determine whether the lawyer's code about reporting concerns of a lawyer's impairment should be modified from what exists today. And I can assure you, they're going to look at the new Judicial Code to say, is this superior? Should the lawyer's code be changed in any way to reflect what the Judicial Code is saying? So there will be changes to come at some point in the future.
Well, it's a brave new world, and I think I have to tell you all. The other day I was in a meeting. There were a bunch of lawyers there who've been trying cases for a very long time, and they started telling war stories about when they were young lawyers, and their mentors would. Lunchtime would come and they'd be over at the, Mayor's Row here in Chicago having a liquid lunch and go back to trial and beat up the expert witness and do an incredible job. And it just, or a terrible job. It didn't matter, but it's a different day and age.
Yeah. And speaking of different days and age, it's harder on Zoom. It's much harder.
All right.
Believe it or not, I had matters that were generated at the ARDC where a judge brought to our attention the fact that that judge believed the lawyer was impaired. And that judge called in the sheriff and had a breathalyzer test done.
Really?
Yeah, in chambers. Okay.
Wow.
And the lawyers were impaired. So the judge basically said that, well, I'm continuing this proceeding and I've got to do something about this. So it's these are horrible situations.
Can they do that? I know you can do it.
Michael is asking.
Let's hear
here,
Judge's
what
answer.
happens- Michael is asking, what happens when a judge ignores Rule 2.14 when an attorney is clearly under the influence of drugs in court?
Right, so if the judge ignores Rule 2.14, then Rule 2.15, if another judge knows that the judge ignored it and violated something, then the judge has the duty to report another judge. So it's putting all these extra safeguards in there just to, again, emphasize how important it is that, number one, we don't tolerate this behavior, and if it's going on, that we take appropriate steps, whether it is reporting it to ARDC or Judicial Inquiry Board, or again, if it's a lesser level of knowledge, then it just says that you have to take an appropriate action. That could be talking to the lawyer in private, so long as it doesn't violate ex parte communications. You can sometimes find them in contempt if you want to go that route, but at the end of the day, you want to get them the help they need.
Right.
Yeah, and you know what, Bob, the one answer about the Lawyers Assistance Program, it's not only the program itself, but those volunteers over the years, especially in the communities, are so important. There's nothing wrong with reaching out to the Lawyers Assistance Program to get information, because how many of us know how to deal with situations like this? Yeah. So it's always critical to know resources are out there to help you.
Yeah, that's great. Well, thank you. Okay, Pam, hypothetical number 7.
Yeah.
Okay, this one. All right, now Betty Rubble. Here she is. She made it. She made it.
Can't leave Betty out.
Yeah, where's Fred? Okay. Has filed a motion to disqualify opposing counsel due to a conflict of interest. Betty's opponent represented Betty's client more than a decade ago and has performed no legal services for the client since then, the former client. The judges ruled that the older matter and the present action are not substantially related and declines to disqualify the counsel. Betty looks at the judge and says, "You are so wrong, but I guess that is why God created appellate courts." Storms out. Okay, here's the question. Is Betty's comment proper in as much as she is giving the judge notice that she intends to take an appeal? All right, I dare anyone to go down from the 100. Let's see here. Oh, they don't. Okay, here we go. All right, there's some free spirits out there. Here we go. Let's see if you can get over 15. I don't think so. No, it's peaking. You're peaking at 12, 13. You're peaking at 13. You're only on the edge there. All right. There we go. Well, Judge, what do you think about this one? What would you do if that happened in your courtroom?
Oh, gosh. Well, obviously people threaten to appeal all the time, so that's okay. But it's the manner in which it was done. And again, it goes back to the order in the courtroom and maintaining civility. So I agree with what the panel said. So,
interesting. I can't remember when it was, but I thought I heard the argument, Judge, that ruling this is in a sidebar and we're in the trial. That ruling is just frank air. You're going up. That's terrible ruling. We're going to be appealing that one, and I'm thinking to myself, boy, that's really smart of you to be telling the judge all that stuff. If this case is still going on, does that happen at all nowadays? Do people try to intimidate you that way, or do you see it happen?
Yes,
Really?
they do. They try. So.
All right. Well, luck for them. Well, we got a substitute, another hypo here, Pam. It's still on 7. So Betty she's still upset that the judge denied her motion to disqualify opposing counsel. And as a result, Betty lodges a complaint against the judge with the Judicial Inquiry Board, the JIB. And at the next court session, Betty argues that the judge must enter an order of recusal because in light of the complaint, the judge can no longer be impartial. Is Betty's route the proper way to resolve the matter? Well, that's an interesting one too. So that's an interesting thing, Judge. I was compelled to file a JIB complaint against you. How can you hear anything further in this case? You know about it. You can't hear anything anymore.
Well, again, they can file a motion to substitute. It'd have to be for cause, get sent to another judge. I highly doubt a judge would grant those, but they try to say we're going to be, you know, biased toward them, but we have thick skin, so no, we can handle it. And
There you go. All right, so I think 96% say Betty was taking the wrong road. She got, as Yogi would say, she got to the fork in the road and she took it, but she took the wrong one.
Right.
Okay. All right. And then, so now, next one. Betty's client sends the judge a letter. Betty's got a good, they're piecing it out. Betty's client sends the judge a letter that is delivered to the judge's chambers. The judge starting to read the letter and was reading it before she realized that the letter was written by a party litigant. The letter reads in part, quote, "My lawyer told me that she needed me to pay her $20,000 so that she could pay you some money to rule in my favor. I gave her the cash and then I found out she spent the money at a casino." Wow. Okay. Now that's happened. So let's see what should the judge do? Multi-part questions. Immediately recuse herself. Report the attorney to the ARDC without further proof. Immediately call in the attorney and ask for an explanation in chambers. Immediately call the parties for an emergency motion to get to the bottom of it. Do nothing. This letter obviously was meant for a different, was not meant for this judge. All right, let's see what the assembled think here before we,
I think
okay,
Jim
so
Grogan has a comment on it.
go ahead, Pam. You can ask your question while the vote's coming in.
Well, I was gonna say, I think Jim Grogan is dying to talk about this hypo.
Is this the truth? Is this a real case, Jim?
There have been real situations, yes, where you know, lawyer tells client, give me money because I'm going to pass it off to the judge. Not saying it's only Cook County, Bob, though. I mean, you know.
Okay.
But,
I've heard of these situations, to be honest, not for a long time, but as a
right,
young,
it's the lawyer shaking down the client essentially, and talk about a mess. Here's my thought when this problem enters the door, and I'd be interested in the judge's comment, but you know, if this comes to my attention, when do I bring in my chief?
Right.
You know,
Judge, how would you handle such a letter?
Yeah, so obviously it's, well, you do guys, the question is down at the bottom about the chief. When's the chief get involved? Yeah, you have to report that behavior. You do have to question the lawyer about it, for sure. For sure.
I don't know what the ARDC, yeah. A lot of people think it'd take it to the ARDC, but I don't know what the ARDC would do with this. Anything, Chris?
Yeah, I mean, well, Grogan, go ahead. I don't want to.
Go ahead, Chris.
I was going to say, I think there'd be a lot to question about this, right? Whether or not this is something to disrupt the tribunal, delay the proceedings. If it was legitimate and it was a client shakedown, you know, if I were at the ARDC and saw this, I'd be asking lots of questions of everybody. So I certainly think there's a few issues implicated here.
Well, the first thing too, it is a letter, it's an ex parte letter, right?
Okay.
So we have a duty to disclose that to all parties. Typically what I do is just say, you know, court's in receipt of this ex parte letter, we don't respond to it, and then I instruct the clerk to make a copy and then seal the originals. But when the other side gets a hold of this, I'm sure their red flags are going up and they may feel compelled as well to investigate more or contact ARDC.
There you go. All right, Pam, let's go to the next part of this. Where the judge is concerned about Betty's entire course of conduct. And as a result, the judge pays a visit to the division's chief judge. The chief hears about Betty's course of conduct and says, "It ain't easy being a judge. Why don't you just toughen up and live with this instead of bothering me?" Oh, that's real good. Okay. Jim, what do you say about that one, buddy? Chief judge needs to get involved. Should the chief judge get involved in a case when a judge is uncertain as to what judicial mentors are for? What are judicial mentors for?
Oh gosh, yeah, the chief needs to get involved, please. Are you kidding me?
There you go. And you know, it's interesting. I mean, that's kind of my whole. At the beginning, we were talking about the idea of you know, of Zoom and you know, can you practice law without being in person and engaged? And this is you walk down the hall and you see your colleague and you get some advice and you get some osmosis work. So, and that, the vast majority believe you go down to the chief, and the idea that the chief, he's got a lot to do and too busy for something like this is kind of a non-starter for.
Bob, as a rule of thumb, in lawyer regulation, and Chris can, I think affirm this too, is we would constantly talk about problems that came up, and we'd always ask ourselves, the Supreme Court, composed of 7 justices, what would they think of this situation? How would they want us to address this issue? And if necessary, is this a case we should bring to them for their review? So this is something that I would think that 7 would want to get involved and know what's going on.
Yeah, I agree. Okay, Hypo 8, Pam.
Right.
The judge has scheduled a remote hearing in a breach of contract case. All of the lawyers and counsel are required to attend the session via Zoom. After the case is called, the judge notices that plaintiff's counsel, Marge Simpson, is not present. This is the 3rd remote session that the court has held in the case. In the 2 prior instances, Marge has been an hour late for each session. On each of those occasions, Marge informed the court that she is not technically savvy and that it takes her a long time to figure out how to access the Zoom platform. Well, okay, is Marge's comment subject to discipline? Comment. Wow, let's see what everybody thinks about that one. Really? Okay, Marge is in trouble. Oh, all right. Somebody turn off the lights in my office. It's funny. We're in fairly new offices, and if you don't move around too much, the lights go off. And so yes. Yeah, so I'm going to have to turn the lights off while you guys are talking. All right, so here, Marge's comments are subject to discipline. Less than half think so. And so, Jim, what do you think about this one? What do you say? Well, actually, this one ought to go to the judge, because
oh yeah,
you got to deal with this all the time. Where geez, I can't get my mic to work, and where's the video thing?
And here's the things about the ethics rules. They're not intended to involve regulation all the time. This is something that's best left to the judge to decide how things should be managed in the courtroom. Because the judge, with her administrative and adjudicative responsibilities, should be the one to decide what to do. There may be a point, depending on the conduct, that the judge wants to say, I'm going to do something about it. But luckily, the judicial rules are crafted in such a way to give that judge a lot of discretion to respond to conduct by lawyers that may not be all that great. It could be such that the judge says, I'm going to set these parameters. I'm doing A, B, and C. And you do know, counsel, that you have a duty of competency. And that includes the fact that you have to be competent as to, electronic devices that you might employ as part of your practice.
Well, not only that, I mean, this is a plug for, all the ISBA and the local bars. I mean, they will conduct and do conduct introductory classes on these things for their members. You can go to this stuff, all the time. Certainly within a law firm, we do teach this stuff. Like a big area for us now, and we may not get to it today, but it's ESI and how to process the cases where they do a big dump of documents on you and pages and what to deal with that. So, you're right. I mean, and look, for the modern day practice of law, I can tell you, you either get with this technology or it's going to blow right by you.
Right.
Right. Now, something that's kind of not discussed in this hypothetical is the question is, are her comments subject to discipline? And I think they're disrespectful, right? And, they're obviously, she's not taking the effort to become familiar with the expectations in our electronic world now. But her failure to timely appear could be sanctionable. Right. And that's a key, because Okay, so if you can't access it by Zoom, Supreme Court rule talks about how courts have to make in-person an option if, let's say, a self-represented litigant. So I would say the same could apply for lawyers if something is going on and if there's an impairment, some disability that is preventing this lawyer from, appearing remotely, then they can appear in court, but just to be an hour late is not acceptable. And I don't know of any judges that would tolerate that. So I think that her being late routinely could be subject to some type of discipline.
So
Yeah,
Pam,
this
let's see if Marge's tales of woe continue in our next.
Okay,
continuing.
yes, they
So,
do.
Marge finally shows up, but this time she's only 5 minutes late. And instead of a live feed camera, Marge is using a filter that is displaying a picture of Ruth Bader Ginsburg. When the judge asks Marge to take down the photograph and turn on the camera, Marge says, "This is remote. You just need to hear me, not see me." And when the judge threatens to hold Marge in contempt, Marge says, "Judge, the real reason that I don't want to turn my camera on is because I never wear clothing in my home law office." Okay, Marge. So, all right. So now, is Marge's speech conduct protected? You remember at the beginning of Zoom in the pandemic, there was that guy in Florida that couldn't get the emoji off of his screen during a Zoom hearing, and it was like a bunny or something. He was a bunny for the entire hearing.
It was a kitty cat. Yep.
Yeah, kitty cat. So, okay, Marge's speech is not protected, and I think we kind of all agree on that one. But what if Marge offered to post her law firm's logo on a screen simply with her name? Can the judge require Marge to appear in person with a live camera feed? What do you think, Judge?
All right, so here again, I know the Supreme Court just came out with its Rule 45 on remote proceedings, and then within that it talks about local rules, and the local circuits can establish what type of decorum they're going to expect. So for our local rules, we require the camera to be turned on. So here, if there's an absolute refusal to turn on a camera, because we interpret these Zoom and remote hearings as courtroom proceedings, it's a convenience now to the parties, the litigants, but we still expect the lawyers and the parties to treat this as if it were a courtroom, and they wouldn't come into court with something over their face, right? They would come appropriately. And so we do have that expectation. And so, yeah, if she did not turn on her camera because she's not properly clothed, then yeah, we could require her to start appearing in person.
And what is the remedy for not doing it? Would that be a finer or sanctioner, or?
We could just terminate it. We could say, sorry, we're going to show you're not present for court today, and your presence is unexcused.
Okay.
That could be a remedy.
There you go. You were shaking your head yes there, Jim. You got something to say?
It's just, I feel sorry for the client that has retained Marge.
Hey, amen to that. I mean, that's there you go.
At least Marge is being honest about it. I kind of just want to turn that on its head too. This really hasn't been an issue as of late, but I think this was a question flipped on its head, right? Whether lawyers could wear masks in court, right? And judges recommending that they needed to or didn't. So I think there's at least some debate on, like Judge, you referenced the local rules and what they require. I think it's interesting if somebody were to just take this a little bit and say, yes, you need to have a live camera. I think your hypothetical was you can't have something on your face. But what if somebody wanted to wear a mask and the judge said you can't wear it?
No, not on your face. I just meant you would have come in a full, you're present. You're not coming in a costume. You're present is my point. I didn't mean any face coverings like that.
Well, Chris,
the whole mask debate. Yep.
But Chris, I have a question. Does any, here you are. I mean, you're with, one of the best insurers in this state and nation on. Does this stuff tell us the context in which Zoom proceedings, navigate your world? I mean, I'm not sure how they do. I mean,
yeah, I mean, I think this is kind of changed as rapidly as we have with, entering the pandemic, leaving quote unquote the pandemic, and circling back. I think how lawyers have navigated both what they wanted, what their clients have wanted, trying to balance a client's or witnesses' desire to be in person versus remote, and how they want to show up in in a remote proceeding, whether or not that's going to affect, how the witness's testimony is judged, whether their credibility comes into question. Those questions I think have come up, and that again is changing as, it's going to depend on the flux of how these remote proceedings continue. But those have come up a lot. And how do I handle what I need to do as a lawyer and law firm versus what my client, right, might necessarily want, or what the judge is asking for? Those questions continue to come up.
Hey, Judge, what about this one though? This kind of came up recently. Am I allowed, let's say this is a hearing right here. Am I allowed to be taping this, recording this?
No, you cannot. If it's the court proceeding, no, because it's the same rules apply. No one can be sitting in court unless you're the media and you have permission, and you have to fill out a special request with the trial court administrator, and it has to be approved. So if you're sitting in court as a lawyer, a witness, or a party, you cannot turn on your little video recorder.
Yeah, I see that little button right there. I could hit it right now. It says
right. So the court,
computer.
right. Yeah, the court can, and I will always tell everyone, listen, I don't have a court reporter in here. We have electronic recording, but I'm doing this as a backup. So I let them know I'm recording it if I don't even have a court reporter, just as a backup. But I let them know they're not allowed to record it, and that's just part of the rules. So, and again, you were extending the rules that apply within the courtroom itself to these Zoom remote proceedings. So no, they cannot record them.
Okay, thank you.
A simple question from Don asking, is a coat and tie required for a male's Zoom appearance?
Oh,
Who's asking?
a gentleman is asking if
Gentleman online, Don.
Johnny wants to know if he has to have a coat and tie, or can he show up in his polo?
Yeah, so I think, again, you have to look back at the local rules, and then individual judges have their own individual expectations. Whatever the judge expects when you appear at the courthouse, this is an extension of the courthouse, so just make sure you're in compliance with that judge's expectation.
The new judicial rules didn't change that.
No, it does not say that.
Yeah, we had, this is true story. We had a deal the other day, a Zoom, and during the proceeding, a lawyer had to get up and go get a document on the other side of the room, and he's in a coat and tie, right? And he gets up and he's got Bermuda shorts on.
Oh, no.
There you go.
Oh, well,
Okay, all right, Pam, let's go to hypothetical 9.
Yes, thank you. Yes.
Okay, so Louise' lawyer represents Carolina client in her divorce. Carolina fired her previous 2 lawyers, and Louise' lawyer is the third to take on the matter. After working with Louise for approximately 1 year, Carolina client decided to terminate his services. She was directing Louise to take no further action on the matter, and after informing him of that, stopped communicating with him. Louise' lawyer moved the court to withdraw from Carolina client's case, which was denied. In doing so, the Judge Jones cited the long line of dismissed lawyers on her behalf, the ongoing discovery, a myriad of discovery-related motions that are set for hearing, and the court's belief that Carolina client's decision to terminate Louise' lawyer was nothing more than another delay tactic. And okay, after denying Louise' lawyer's motion, the judge continued the case and instructed Carolina client and Louise' lawyer to resolve their differences in order to proceed with the pending motions. Despite that, Carolina client has remained entirely non-responsive to Louise' lawyer and has now sua sponte filed several pro bono motions, none of which Louise' lawyer was aware of. You know, that can be a real life situation there. Is Judge Jones's denial of Louise' lawyer's motion permissible? This will be a good one. Let's see what the assembled think about this guy. I mean, he's kind of in a pickle there. The lawyer won't communicate with him. The judge won't let him out. The lawyer, client's now taking affirmative steps to show the judge that she doesn't want him as the lawyer anymore. The judge is frustrated, you know, but let's see, the majority says that the denial's permissible. Yeah, the permissibility is winning. I wonder who filed the divorce. You know, that's got maybe that a little. All right, so I think the majority is saying that the judge's denial is permissible. Judge, what happens? Do you agree?
You're on mute, Judge.
Thank you. Yeah. Again, I kind of have to look at the totality of the circumstances here, but under Supreme Court Rule 13C3, it does say that the motion can be denied by the court if granting the motion would delay the trial or otherwise be inequitable. And I'll let Chris speak to professional rules under 1.16, I think it is, maybe.
And Chris, add to your comments if you would. What if something went wrong in the meantime, and then the client says, "Well, you were still my lawyer of record. I'm going to sue you, buddy, for things going south."
That's exactly what's going to happen. This is like the worst game of musical chairs that I can imagine, right? You are the last in a long line of attorneys, and now here you are stuck without a chair trying to figure out what you're going to do. And quite frankly, we've seen things like this where attorneys are stuck between a rock and a hard place. And how do they get out? How do they communicate that to the client who's non-communicative and to a judge? Cases are resolved. And so, of course, the judge is going to say, I've seen the other delay tactics. I'm not going to be a part of that here. We need to move this along. And so, what I think, the lawyer is worried about is all of these duties of following their client's directives, to their last known directive to withdraw, while also trying to remain in line, complying with a court order as an officer of the court, but knowing full well that, of course, if something goes wrong, this client's probably going to end up suing them for malpractice rather than just finding another lawyer. And so this is, the right route. Is it permissible? Yes, it is. It's probably not a great ruling because hopefully the judge would recognize the really difficult ethical quandary that the lawyer's in, right, with these concomitant duties. But, it's probably not great. And so maybe I would look to try and reconsider, but when you are declining that representation and the client's already made it clear, you now have a duty to take steps to protect the interests of that client, to make sure that their interests aren't diminished or that they don't have any negative consequences, to make sure they get their file, that it gets to the next lawyer in the right manner. But when you've got a client who's, again, is not talking to you and is now filing things pro se, you're kind of stuck between a rock and a hard place, other than to try and wave your arms in the air to get the court's attention without disclosing too much information.
Jim, what's your perspective on this?
Well, especially since these pro se filings came after the judge denied the motion, you have to bring it back to the attention of the judge and say, essentially, this litigant can represent herself pro se. She's doing it anyway. She's filing these things. She's not communicating with me. And my continued representation could cause me to have problems with the ethics code. So I think you'd have to create a solider record about trying to get out once more.
Yeah, if we were live in DePaul like we used to be, I bet you he's on the line. My dear pal Miles Bierman, who's got one of the largest and most well-respected family law practices out there. He's probably had this situation. I'd love to hear that perspective, because this to me is once again one of those things where you would seek ethics counsel to get disclose what you can, and maybe file a motion, renew the motion, but also have a declaration by that ethics counsel that says that, I was retained by this lawyer, I've consulted with this lawyer in accordance with the Rule 1.6, confidential information has been revealed to me, and based on that, I've counseled that they should go make another motion because good cause exists, in my humble opinion. Something like that. I think, and that would, I think, be persuasive, or certainly the judge would pay attention to it. I think, Judge Troemper, do you agree?
I agree. Definitely, I would not be offended at all if the lawyer came back and said, Judge, I really want you to reconsider this, and here's the reason why. And another possible solution in the interim is the judge could actually delay ruling on that motion, say for 30 days, to see if the client could retain new counsel within that 21 days and then bring them back for a status, and maybe more information would be gained through that additional delay. But again, I think just asking the judge to take another look at it's the right approach. So, and getting ethics opinion from outside resource.
And I think, Pam, we have a couple of additional hypos to this where we get to see what the assembled might think, but
honestly, we're getting a lot of questions still on Betty Rubble. They're disturbed, and would like the panel to address Rule 45 regarding the Zoom and how disabled attorneys require accommodations. And how do you accommodate the disabled for Zoom? And they'd like the several.
Is Rule 45 in our deck, Pam?
It is, yes, it's at the very end of the stack.
Great,
Yeah.
so if you could talk about that for a minute.
You want to
because,
pull up Rule 45?
Rule
Jump
45,
ahead.
there it is.
Yeah, there you
Remote
go.
appearances.
All right, so I mean, I think the court goes out of will certainly go out of its way to accommodate disabled people. So what's the question then?
I think the question was that it was left that somehow, I think people are saying that if a person is disabled, that you can't, that the court is required under this rule to make accommodations, as you're saying. And they're also asking, can the media record court hearings via Zoom?
Again, depending upon your jurisdiction, for media to be present in a courtroom or court proceeding and record it, they have to seek permission from the trial court administrator, is my understanding.
Right. I mean, I think that the media can certainly be present and report all they want, but I don't think there's a media recording privilege.
Right.
Right. At least in all the courtrooms I've been in. So I think that there's that one. And so I hope that answers the remote. But I think, Pam, yes, but accommodations have to be sought. They have to be, the court can't be, you can't presume that the court knows about the needs until you bring them to their attention. I think that would be a fair comment.
I think, yeah, that's a fair statement. Right.
All right, so let's go back. Okay, then let's go back to poor Louise's problems and just make sure we cover everything there. File a motion to reconsider. I think we all agreed on that. Follow the client's instructions. I don't think anyone even voted for that one. Continue the representation as ordered by the judge to a point to, until you can pursue other remedies. And then tell the judge that she requires a psychological exam before the court proceeds any further. Well, that's an interesting one. Query as to whether or not you could do that under seal. And that's where you need to get ethics counsel. How far can you go? Having been there, done that, I'm telling you, there's a legitimate issue, even with your ability to seek counsel. How much information can you disclose in that you then are permitted to disclose to the court? It's you need help on that one, folks.
Bobby, raised something very interesting, because you might have a client with diminished capacity, which will, invoke another rule in how you proceed, which is 1.14 of the Lawyer's Ethics Code. And you certainly may want to reach out in those situations as to how to proceed. If you believe that that client might no longer have the capacity to be able to deal with you or deal with the court.
Yep. All those folks out there are going to think that I'm hawking the services of outside ethics counsels. I haven't named any names, so there you go. I can't be accused of that. There you go. But I am really saying the need. I mean, things are getting very complex in these cases and very slippery slopes. And then guys like Chris will say, well, I'm not giving you coverage for that.
And if I could give a plug too for the Illinois Judicial Ethics Committee, we have a website as well. And you can submit an inquiry there for any ethics issues you may have, and we present it to the whole committee, and then we issue a statement back. Sometimes we author opinions depending upon the unique issue raised. And also the Illinois Courts Commission has a website and has resources available to seek opinions, ethics opinions. So yes, don't be afraid to reach out.
There we go.
And Philip is asking, does the ARDC take any action where a pro se litigant is unhappy or aggrieved against an adverse party's attorney and files a frivolous ARDC claim against the attorney? How do you handle it with a pro se litigant?
I don't understand the context, Pam.
I think it's in context of this last hypothetical in terms of if it happens to involve a pro se litigant instead of an attorney. What does the ARDC, since we have a couple of previous ARDC people, how would it be handled?
The ARDC only has jurisdiction over those who are licensed, unless it's an issue as to the unauthorized practice of law. So if it's a pro se litigant, let's say someone who doesn't have a law license, there's no jurisdiction. whatsoever by the ARDC.
But then we're being asked also, there is an absolute right is being questioned to discharge a lawyer for any reason, however ill-advised.
That's right. But as the judge noted, we have that Supreme Court rule that deals with appearances, and it ain't over till the judge says it's over.
Okay,
There you
thank
go.
you.
All right, hypothetical number 10, Pam.
Right,
Okay, we've got Judge Jordan and her staff maintain a small email account known as Proposed Order Mailbox for the purposes of receiving proposed orders from parties before the court. A case involving the alleged wiretapping of an ex-husband's email communications is before Judge Jordan. She recently received plaintiff's request to extend discovery so that the plaintiff could depose an additional witness. In response to this order, plaintiff's counsel sent the following emails to the proposed order mailbox. Quote, "You are violating my client's rights by truncating discovery deadlines and helping defendant to escape punishment for wrongs he committed." And then, quote, "I'm sickened by this order and outraged by the miscarriage of justice." And then finally, he goes on to say, this very smart lawyer, "The more I read the order again and again, I am sick of my stomach and I get filled with anger and disgust over this fraudulent order by this court." Wow. Hypothetical, are these statements protected under the First Amendment? And should the lawyer be disciplined? Let's talk about the First Amendment one first. Okay.
I think the judge was going to address this. And
Well,
I believe it's
we gotta
based-
wait for we want to see what the audience says first.
Okay,
All right. So far, the lawyer's losing in the First Amendment department.
Always the case.
There you go. I don't think that lawyer's going very far. We're gonna stop there. Judge, what would you do about this, Judge?
Yeah. So I would slightly disagree with the overall result so far. I would say that technically they are protected by the First Amendment, but does not mean they are protected from discipline. I think that's the distinction. But the one that might not be protected from further recourse is the allegation of fraud. I think that you have different issues there where you're suggesting the court has committed fraud, and that could be defamatory also. But no, I think that while they may be allowed to say those things, doesn't mean they are going to be protected from further discipline or sanctions.
Okay. Well, there's more. We want more. All right. And Pam, turn to the next slide. So
yes,
should the lawyer be disciplined? I think the judge just kind of addressed that. And there's a whole lot of folks that believe the answer to that is a yes. How about disbarred?
Yeah, no.
All right. Isn't that the next question, Pam?
yeah, this is an ABCD.
Yeah. Yeah.
Yes,
This, okay.
typed in the
Disbarred,
letter.
lengthy suspension of the license, forced to apologize to the court, anger management. That's not bad. Anger management classes. All the
Well,
above.
I think this is based on an actual case in Illinois. So it's not far-fetched. I think Chris is very familiar with it, in fact, aren't you, Chris?
Really? Chris, Chris, fill in the blanks here, buddy.
Yeah, sure. I mean, I'll speak on the hypothetical.
Okay,
This is based on an actual case, and the actual case is the complaint that I filed when I was at the ARDC. So I won't speak on the actual case, but the Supreme Court just recently ruled on it. And they
Yes.
essentially said, this is exactly the type of conduct we want to prohibit, right? You're disrupting the tribunal, you're engaging in conduct prejudicial to the administration of justice, but just as importantly, as Judge mentioned, it's that fraudulent, it's a comment about, fraud or the fraudulent order, right? And so once you start impugning the integrity, once you start falsely impugning the integrity of the court, without any sort of basis whatsoever, that's when you start looking at 8.2 violations. And the court, again, as Jim mentioned earlier, the ARDC constantly thinks about what those 7 justices would think, how they would want, the court to be able to run its call, and how they want judges to be able to be treated as well by lawyers, how lawyers should engage in civility. And so this is another recognition of that, of without any basis whatsoever, an attorney repeatedly, as mentioned in the hypo, an attorney repeatedly making these comments, and typing them out in an email and sending them off. Again, they're not even, oral comments that could be described as one-off. This was an email that was typed out, sent, hit, thought through and then repeatedly gone to the inbox. And so the court really took, will take a look at this and certainly will impose some sort of discipline. And, it has recently that involved some combination, of these. And I think that's ultimately what we want to be able to focus on as Judge and Jim had discussed.
And it isn't just punishment. The court is very adept at fashioning a sanction that's appropriate. If this is a young attorney who did something foolish without the benefit in their career of mentoring, perhaps the court can say you can learn. And if you can learn, maybe we can fashion something along the lines of a probation and make sure that you're monitored for a while. Because it's not easy if you're a young person getting into the practice and you don't have an established lawyer to help you understand the process.
Okay, well then, perfect. Pam, let's go to Hypo 11.
Right.
So you've got a local nonprofit organization that provides legal services to those with mental health needs, mainly some of these lawyers we've been talking about. And it's just opened, and a new large office there's in a new large office and expects to grow in the next several years. Currently, there's an extra office space, and the executive director, Leroy Lawyer, is worried about meeting rising bills until further funding for the space is available. So Leroy, a lawyer, learns that a piece of it is available, and that he learns about this from his niece, Thelma therapist, who's looking for an office from which to run her mental health counseling service. Leroy rents space to Thelma. Once again, Leroy's not profit. Thelma is for-profit, who has no affiliation with the not-for-profit. Thelma has no affiliation. After a few weeks into the arrangement, one of Thelma's patients has sent a bill for her services. The patient hires an attorney to sue Thelma and Leroy Lawyers organization, claiming the counseling was part of the services provided by the organization. So the question is, the operative question is, did Leroy Lawyer violate any ethical rules by allowing Thelma therapist to open her for-profit counseling center in a not-for-profit legal organization's place of business? Well, Mr. Chris, what do you think about that one?
Yeah, this is the question that, we get a lot too. And certainly part of it is, what are my ethical duties? The second question is always, what am I going to be covered for? But I think when you talk about these dual roles of lawyers, people who are lawyers or have law licenses, while also sitting on boards of nonprofits, or in this case, an executive director, the question of when we take our lawyer hat off is always running through their minds, and always whether or not that creates a conflict of interest, whether or not that makes, creates additional duties. And so, Leroy's right to think about, whether or not this is something that is violating the rules. And it seems right for the question of how do I think this through? Should I have opened up this office to this therapist to be able to provide a service? Because what they're trying to do is ultimately, and the goal is right? Lawyer wellness is such an important part of the discussion these days. We want to make sure, people are getting the appropriate services they need. But more importantly, is this something that's going to implicate his law license and any disciplinary issue just based on the fact that he's a lawyer? So I think, the assembled have it right here, not necessarily any ethical rules implicated, but the questions remain of the lawyer, really needing to clarify their role, the fact that they're acting as an executive director and not as a lawyer, not on behalf of a client, what your legal services, for this organization will include, what they won't include. And so that clarifying communication at the outset, I think, is really going to be important, particularly when you've got lawyers in this dual role, boards of nonprofits while also doing some legal work. I think that's paramount to this question.
Okay, good. Let's move on. I think, Pam, if we can, to Hypo 12, because this one's pretty interesting. We've alluded to it a bit already, because this is very, very everyday practice nowadays. Plaintiff's firm is handling a highly complex matter that involves alleged wrongful conduct by corporate executives. Plaintiffs have asked the defendant corporation for a variety of documents, and after many motions and months later, the defendant corporation delivers to plaintiff's counsel more than 100 boxes of materials and zip drives that include thousands of emails that may or may not be relevant. Plaintiffs go into discovery on a motion asking the court to order a discovery conference for the parties to narrow some of these documents. Defendant corporation objects and argues that it has complied with the request, even though millions of pages are involved. What should the court do? So here we go. We've got a
Multiple choice.
yeah, multiple choice. Deny the plaintiff's motion. Defendant produced everything asked for. Grant plaintiff's motion and order the parties to meet and confer to ensure proper documents discovery are discovered. Order the defendant corporation to purchase a software program that is amenable to the needs of the plaintiff's request, and tell the parties that either they figure out what to do or you will dismiss the matter because courts don't have time for micromanaging. Let's see what the assembled think. I'll bet you judge has a view about this. I know I do.
I think Chris and Jim do too.
There you go. All right, so to begin with, deny the motion. Very few people believe the motion should be denied. The majority of people believe that the motion in order should be granted, and order the parties to meet and confer. You know, I hate that term. I've been meeting and conferring my brains out in the last couple months. All right, to ensure that the proper documents are discovered. Judge, how would you handle this one?
Yeah, so I would agree. Letter B is the only reasonable option out of this one. Obviously, courts do not like it when the other parties make it difficult for the other party to identify which documents go to which request, and just saying, here you go. I don't think that's complying with the discovery rules as well. So yes, the reasonable solution under this fact pattern is to have them meet and confer and try to reach a resolution.
Chris, yeah, I saw you laughing. Have you dealt with this, Chris? And
yeah, I just think there's nothing and Judge, you attested to it. There's nothing judges love more than mediating discovery disputes, right? I feel like you can meet and confer a million times and they come back to the court no matter what. You know, I would hope the meet and confer comes before any other motion on that end. But this kind of thing happens, especially with, you know, the long ago advent of electronic, material, electronic discovery. But the more and more documents and data that is retained, the more you're going to see these document dumps. What do you do when parties engage in this? And so I would hope, as Jim said earlier, the lawyer's job is to try the case for the client, not to make the judge's life difficult. That's what I would think should be the mantra going forward. Judges don't want to get involved in this.
Jim, do you have any thoughts?
Well, believe it or not, Bob, I'd be more interested in your thoughts given the extent of your practice and the nature of your practice.
I have some, and I think that on this particular subject, if you're not careful, the producing parties can weaponize the process. For an example, just a bulk document dump is improper. I think a party is entitled, for an example, to know what documents are responsive to which requests. I don't think there's anything unreasonable about that at all. Secondly, the idea that here it's stated in the example that thousands of emails that may or may not be relevant. I don't. In the federal system, there was this pilot program for a time that allowed the opposing party to define relevancy, and that's a slippery slope. So certainly ordering the parties to meet and confer, to come up with a meaningful plan so that there's an organizational structure to production is really required, and you're entitled to that. And then the second thing that, at least from a litigant's perspective, you really need to understand ESI, electronically stored information, and how it is assembled and how it can be produced. There's and it can be extraordinarily expensive, because if you're going to handle one of these cases, not only do you have to have a plan for how you're going to request the documents, you have to have a plan for what you're going to do with them and manage them once you get them. Are you going to use an ESI consultant? Are you going to rent a relativity license? How are you going to organize these? Who's going to host these materials? There are companies that host these materials, and they will charge you for a monthly fee for credentials to everyone who has access to these materials. You know, the whole idea of you know, not being organized is just unthinkable. If you go into a case and where you're not prepared, then you're in trouble. And then finally, you know, what I was addressing right now was, you know, for example, the litigation I'm currently handling with Boeing, or the national opioids litigation, or in the past, you know, there was a big State Farm case where we're dealing with literally hundreds of thousands of documents, which implied many millions of pages of material. You have to have a plan for that. But it's not just the big case that matters. It can be the small case. Give me a medical malpractice case and tell me how in a medical malpractice case you are discovering the medical records, and are you getting all of the metadata? And do you know how to search it? And do you know how to seek the materials? This is your job. You know, we talked before about the lawyer that maybe didn't know how to operate Zoom. Well, if you're a lawyer taking on one of these cases and you don't know how to engage in electronic discovery, your client is really being disadvantaged, and that's a violation of the rules.
We have a question here, Bob, that aside from somebody saying that the judge may appoint a special master to resolve the ESI issues, but to what extent, someone else is asking, Nicole, does the rule stating that documents need only be produced as they are kept in, quote, the ordinary course of business, impact this analysis?
Well, at least from my perspective, I mean, that's the rule, but that's a very manageable thing to handle. If the, you know, that's fine. I don't have a problem with that. So I know that's not much of an answer, but I mean, you deal with that every day, that the clients are, the defendants or the clients are producing in the way they have it in their you know, normal course of business. Discovery models can be crafted that will address that. But this is serious stuff. The minute you get in any case with a lot of documents, you better know how to manage it electronically. That's all I know, because you can miss so much. Right. It's so easy to miss materials. It's so easy to under-identify who are the parties that were the custodians, for an example. You talk about emails, okay? You know, you should take discovery slow early on to make sure that you're identifying all of the custodians that you want, who are going to be the players in the case. And then you identify a program for discovering their and searching their you know, computers, and to make sure that you're getting for the right custodians, and their cross-pollination between custodians and the witnesses. It's interesting stuff, but it's tedious and it's expensive.
Right.
It's a cottage industry. Then you have technology assistant review. That's the latest one, TAR as they call it. And so, you know, we're in this one case that, you know, it's a slippery slope.
And not to scare anybody, Bob, but I was just at the National Conference of Lawyer Regulators in New Orleans last week, and the hot topic there is AI and the full extent of AI. And you know, these are issues that we're going to be facing more and more in the future. So,
well, that's exactly right. And this AI is kind of scary stuff, isn't it?
Yep.
I can write my bar exam answers by AI, isn't that? Or go to law school. All right. We've got one more that I think we can have time for. Looking at the clock here.
Just give it 1 minute, if just in case we want to run through it real quick, because you're right. Technically 4:30 we're ending, but we'll go another minute.
Okay, so this will jump to Hypo 13, which is a defendant doctor gives a deposition in a medical malpractice case, and on cross he testifies as to subsequent discussion he had with hospital administrators regarding the internal studies done by the hospital on the risks of the procedure in the case. The parties take a break, and upon returning, the defendant doctor testifies that actually he did not document those internal discussions because they were confidential. Once again, he didn't document the fact that he had internal studies that were done by the hospital. Now the plaintiff's counsel then examines the defendant doctor regarding those internal discussions, and the defendant doctor's counsel objects on the grounds of attorney-client privilege. has defense counsel engaged in any unethical conduct because he obviously whispered in the doctor's ear during a break? Is his conduct, did he engage in unethical conduct? 50-50 so far. Oh, that means we got half plaintiff lawyers, half defense lawyers here. All right, wait, we got more plaintiff lawyers than defense lawyers here. All right, well, let's see.
I don't know if Jim just wants to quickly address this before we close up.
Say that again, Pam?
If Jim Grogan just wants to quickly address this before we
Yeah.
close.
We will. Jim Grogan, could you speak to this one? I think it's from a real case.
You know, this one was, I thought it'd be closer in terms of the ultimate voting, but you know, ultimately a judge has got to decide whether that privilege argument is going to fly. I will tell you this, so much of the work that we do involves privileged information, and there are exceptions to privilege, such as the crime fraud exception, and a judge ultimately is going to make a decision. So you have to take great care in what you advise your clients, because it could one day be revealed.
Number one,
Right.
I think the lawyer should have objected, what is it, the Medical Studies Act for peer reviews? I mean, that they missed the initial objection, I think, and then it's not attorney-client privilege. Obviously, he coached the witness, so that does create an issue.
Yeah.
You know, and I think, you know, come from my perspective, from the trench, this stuff does go on. It goes on with great regularity. I think that you need to know your judge, and if it's a case where you know maybe early on the court will give you advice about, okay, if this is going to happen in the middle of a dep, do you stop the dep and ask for availability to the court? If you're going, we have some deps where we think stuff like this can go on in advance, and we during the course of a status conference ask the court for its process for dealing with perceived discovery abuses in a deposition. What would you like us to do, Your Honor? Is it within your practice for me to take a recess in the deposition to call you to seek an interim ruling or direction? I don't know, for example, Judge Troemper, what do you do about that? If I had a case in front of you, it's a big med mal case. I know my opponent's a rascal, and she's going to give me a really bad time, and does it all the time. Every time I deal with her, can I ask you, Your Honor, before I take a single dep, can I check with the court's clerk to make sure you're available that day? Because I know that there's going to be all sorts of stuff going on that I'd like to call you about in the middle of the dep.
Yeah, no. I think you'd have to file a motion to supervise discovery first, and then give me a reason why. And then if I feel it warrants it, then we would set a time that the court could be available to take calls or answer issues.
Right.
But yes, no, when I was in private practice, I did have to have a judge supervise discovery because it got out of control. And yes, a lot of violations and egregious behavior in a med mal case. So
there you go. Well, on that note, I think, Pam, we are at an end. We're
Yes.
Closing up, and I want to thank everyone. Chris, Jen, Your Honor, you've been wonderful and spent a lot of time even in advance of today to put this together, and I am very grateful for you doing so. And I know there are over 4,000 other lawyers here across this region who are as well. So thank you, and kudos to you.
Thank you, Beth.
Yes, thank you, everybody.
Well-
And thank you, everybody, for, oh, Judge, did you want to say something?
no, I was just saying thank you.
Okay, thank you for attending today's program, Refresher on Ethics of Trial Work in a Courtroom. Please be sure to fill out and submit the evaluation forms that can be found by clicking on the Handouts Print Capability tab. Certificates of attendance will be emailed to the email address that you used to register to those of you who qualify for credit in Illinois, Missouri, Indiana, and Wisconsin. We will get them out to you in the next few weeks. Thank you again for attending. We hope to see you again next year. Please be safe, especially with the weather out there today. And thank you from all of us at Clifford Law Offices.